What I want to do in this lesson is outline the nature and sources of the UK Constitution. This is the first of the topics that you need to know for your exam for A-level politics, for AQA, and we're going to discuss a number of different things relating to the UK Constitution. We're going to look at basically taking an introduction to the UK Constitution, exploring the sources of the UK Constitution, and exploring a number of principles of the UK Constitution. We'll define a number of key terms surrounding the UK Constitution, such as the nature of it as an uncodified document, an uncodified constitution, not even a document. Look at a number of principles as well, such as the rule of law, and also the principle of parliamentary sovereignty, and then we'll look at the multiple, sources of the UK Constitution that exists. So beginning with the nature of the UK Constitution. To first answer this question, we have to first ask what a constitution actually is, and then we can start to look at how the UK Constitution exists and how it differs from other constitutions around the world. So the first question is, what is a constitution? And in its most basic definition, a constitution is a set or collection of rules and principles for the governance of an organisation. The reason why I say of an organisation is because a constitution doesn't necessarily have to apply to a country or state. A constitution can apply to a company. Companies have constitutions. If you go to university and you join a university society, a society of a university will have a constitution in most cases. So any organisation can be governed and ruled by a number of principles that are established in that organisation's constitution. The constitution of a country or a state, as the name would suggest and as the definition suggests, is a set of rules and principles relating to the governments of that state, the way in which that state is governed, and the rules that apply to that state. And one of the distinctions between the UK Constitution and the majority of constitutions around the world is the fact that the UK Constitution is very unique. And it's unique because of its nature. And we say that the UK Constitution is what we call uncodified. Now, what we mean by uncodified is it means that it's not written down in a single place or a single document. Now, contrary to popular opinion, this doesn't mean that there are no parts of the Constitution that are not written down, that the whole Constitution itself is unwritten, because there are actually quite a lot of aspects of the UK Constitution that are written down. In fact, most of the UK Constitution is written down, but it's uncodified because it's not written down in a single document that we call the UK Constitution. We can't go online or go on Amazon, for example, and purchase a copy of the UK Constitution, just like we can with, for example, the United States Constitution, because the United States Constitution is codified. It is all written down in a single place. I can go to a textbook, or I can go to my copy of the US Constitution that I've got on a shelf over there, and I will see the Declaration of Independence, I will see the Constitution itself, and I will see all of the amendments. This includes the Bill of Rights and the other subsequent amendments as well. So effectively, I can hold the US Constitution in my hand and have the document in my hand. I cannot do the same thing for the UK Constitution. In order to hold the UK Constitution in your hand, you must first be very, very strong, because it's very, very large. There's lots of paper from different sources, and it would be constantly updating and constantly changing. So this is the distinction between the concept of it being uncodified versus it being codified. Because of the nature of the UK Constitution, we have a number of principles drawn from it. So because it's uncodified, it relies on a number of different sources on the one hand and a number of different principles on the other hand. So one of the principles of the UK Constitution is the nature of it being not being entrenched, it being a flexible constitution. Now, codified constitutions, like the United States, this constitution is entrenched. And what we mean by entrenched is it means that the rules and principles within the constitution are difficult to change. So take, for example, the US Constitution. In the US Constitution, there is a process for its own amendment. It requires quite a lot of broad support across the entire United States of America. It requires broad support in both houses of Congress, and it also requires broad support across the state legislatures. And it's a very difficult and lengthy process to achieve the actual ratification of a constitutional amendment. And that's why there's only been 27 amendments during the long history of the United States. And this is why we can see that it is what we call entrenched. It is inflexible. It's very difficult to change the US Constitution. And on the other hand, the UK's constitution is not entrenched. It's therefore very flexible because of the various different sources, and because there is no single process of amending the UK constitution. It's always amending. It's always changing and developing over time. So therefore it is what we call flexible. The UK constitution will change all the time, and when we look at the sources we will see just how much the UK constitution changes. Another aspect of the UK constitution is that the UK's political authority is centralised, and this is why we describe the UK's constitution as a unitary constitution. And this contrasts with the principle of federalism in the United States system that we'll talk about in a minute. But the principle of the unitary constitution, the idea that political and legal authority, at least political authority and the authority to make law, is centralised, is encapsulated in the principle of parliamentary sovereignty. Now, the principle of parliamentary sovereignty simply states that Parliament has supreme legislative authority. It has the ultimate power to make and unmake any law it so pleases. From a legal perspective, we will talk in a second about the political dimensions of this. And again, as I've mentioned earlier on, the other side of the coin, the other side of the spectrum in regards to the concept of unitary constitutions is the idea of having a federal system or a system of federalism. Now, federalism is the idea that power can be distributed horizontally and vertically across the central government, which would be the federal government, and then the governments of the 50 states, like in the United States. And there are lots of federal constitutions around the world. Germany has a federal constitution, for example. And to some extent, we have a federal constitution. The UK does have a system of devolution, where we have regional governments, such as Scotland, Wales and Northern Ireland, that have some legislative power. But the way this is distinct from the concept of true federalism that we see like in the United States or in Germany is that this power that is given to Scotland, Wales and Northern Ireland is power that is devolved from Parliament and is only granted to these devolved bodies because of parliamentary sovereignty. Parliament still has the right to do whatever it wants. If it wanted to, it could dissolve all three of these institutions and pass laws that get rid of devolution tomorrow. It would cause quite a lot of political turmoil, but in terms of legally, it can do that if it wanted to. Which is why some people and some political theorists have argued that the UK's system is what we would describe as, quote, quasi-federal. It's sort of federal in reality, in the fact that in the fact that laws are passed at regional levels, like in Scotland, Wales, and Northern Ireland. But ultimately, from a legal perspective, power is still centralised in Westminster, in the Westminster Parliament. And let's talk a little bit more, in a tiny bit more detail, about the principle of parliamentary sovereignty. Because parliamentary sovereignty states that Parliament has the absolute right to make and unmake any law it so pleases. This has been a principle that was clearly expressed as a result of the Glorious Revolution of 1688, and it was subsequently encoded in the first part of the subsequent Bill of Rights. Now, the reason why we have the principle of parliamentary sovereignty, to really understand that, you have to understand a little bit about English history, the history between the struggle and the tension that developed between Parliament and the monarchy, specifically the monarchy during the Stuart period under the reigns of James I and Charles I. This was a tension and a back and forth that ultimately led to the execution of a monarch, the execution of Charles I and the English Civil War. And then when the monarchy was restored, and when we see a number of back and forth events take place, I'm not going to go through the history in great detail, we see the invitation of the monarchy back into the political system with William of Orange, with the expressed condition that Parliament has the legal authority and we have the simple parliamentary sovereignty. This is what was known as the Glorious Revolution of 1688. and then the subsequent Bill of Rights that was introduced. And this is actually the most fundamental principle of the UK Constitution. All legal making authority is drawn from this principle of parliamentary sovereignty, and all legal authority and authority to pass laws comes from Parliament and is expressed by Parliament. However, it should be noted that while Parliament is legally untouchable, it can do whatever it wants. It could literally pass a law tomorrow that said that it's okay to go and kick the nearest puppies. if it wanted to, it could do that, okay? And it might make it a legal requirement to do that. If this is the case, though, this is only from a legal perspective. From a political perspective, there are technically some limits on what Parliament can and can't do, because Parliament is still, and members of Parliament, MPs, are still representatives of the people. They're accountable to the people through the regular holding of elections. So if my MP does something that I don't like, or votes for a law that I don't like, I can try and vote him out. And so if that happens, Parliament is at least somewhat subject to the people. They're subject to their constituents. Because if, for example, they passed a very, very unpopular law that nobody liked, when it comes to the next election, we would just vote them out. And that would then reduce their power because they won't be in office anymore. So they are at least constrained from a political perspective. And this is what A.V. Dicey described as a distinction between legal sovereignty and political sovereignty, because there is technically a distinction between the two. While legally they can do whatever they want within the limits of reality, from a political perspective they are technically limited by the fact that they are representing the people and represent their constituents. The second principle of the UK Constitution that was described as the two pillars of the UK Constitution by A.V. Dicey, the second of these is the rule of law. Now, according to the principle of the rule of law, everyone is equally subject to the laws of the land. This includes government ministers and any other member of the executive, and also the Prime Minister. And we even have it to the point where if government ministers did break the law or acted beyond their authority, courts have the ability to investigate to see if they had acted, quote-unquote, ultra vires, have acted beyond their authority. And according to legal theorist A.V. Dicey, the rule of law makes up one of the twin pillars of the UK Constitution, this being the second one being or at least the other one being principle of parliamentary sovereignty, as I've just mentioned. And so we have these general principles of the UK Constitution, and we understand the nature of the UK Constitution, but what are the sources of the UK Constitution? Well, because it's uncodified, because it's not written down in a single document, the UK Constitution has a number of different sources. The first being statute law, the second being the common law, the third being constitutional conventions, and the fourth being works of authority. We could previously have included in this list also law of the European Union, but this is obviously not the case anymore because we've left the European Union. So when it comes to statute law refers to laws that are passed by Parliament, namely Acts of Parliament. So, for example, the 2006 Companies Act, that's technically an Act of Parliament, that's technically statute law, okay? And that would technically be constitutional. And they have an impact, as you can imagine, on the alteration of the UK Constitution by simple reference to the fact that you can pass laws relatively easily within the UK system. If there's a large enough majority, this is the case. Now, while I did just mention the Companies Act, for example, from 2006, as a source of the UK Constitution, while this is technically, you could argue that it is true on the one hand, most legal and political theorists argue that there is actually a distinction between laws that are passed by Parliament that are what we call constitutional and have some kind of constitutional status, and laws that do not. So, for example, the idea of a constitutional law, a law that is passed by Parliament that has a constitutional impact, are laws that have a broad impact on the population and maybe describe the relationship between the people and the state, and are, things like that. And they can include things like the Human Rights Act, the Fixed Term Parliament Act, the Constitutional Reform Act, and the UK Withdrawal Act. All of these different pieces of legislation have broad constitutional implications, and they have broad constitutional implications that things like the Companies Act, for example, from 2006, that do not. So the Companies Act is a very long piece of legislation that effectively just regulates the law of companies and all the different kinds of ways in which companies operate. But that's a little bit different to something like the Human Rights Act, which deals with the relationship between the people and the state. The Constitutional Reform Act, which deals with things like the relationship and the separation of powers within the state, like, for example, the role of the Lord Chancellor and the establishment of the Supreme Court. The UK Withdrawal Act, the act that formally implemented the withdrawal agreement to the Brexit, to the active withdrawal of the UK from the United Kingdom. That has a huge impact on the people and the state. So these are things that we would describe as being constitutional legislation, pieces of constitutional law. And because statute law is a fundamental part of the UK Constitution, and because laws can be passed relatively simply through Parliament with a big enough majority, like the majority we have currently at the time of recording, this gives the UK Constitution a certain amount of flexibility. Because if they wanted to, if there was enough political support for it, a law could be passed tomorrow that did whatever Parliament wanted it to do, and this could be a law that passes, that changes the fundamental nature of the UK Constitution. The second of the sources refers to the common law. Now, the common law refers to the laws, rules, and principles of law that are passed down by legal judgment throughout the years. So legal judgment, so case law, so cases and the legal precedents from these cases. The UK has a very long and rich history of legal judgments and principles being developed, and these principles date back to Roman law. There's a reason why at some universities in the United Kingdom, if you choose to do a Bachelor of Law degree, an undergraduate degree in law, you might have to do Roman law. You might have to study the ancient history of Roman law, because it has a number of implications onto the impact of the UK Constitution today. Not too significant impacts. For the most part, the most significant impacts on the UK Constitution are laws that are passed past the Roman period, but they still have some significance and some constitutional implications. But mainly, they date back to, we can trace the common law and we can trace the constitutional principles that we understand to have in the United Kingdom back to this period in ancient history. There are a number of principles and rules that are developed through the common law. So, for example, there are a number of criminal offences that we call common law offences, common law offences. Now, you might not know this, but common law offences are crimes that are not outlawed because there is a specific piece of legislation, but because they are crimes that are developed through the common law. For example, murder. Murder is a crime in the United Kingdom, not because that there is some act of Parliament that makes murder illegal, like some murder act. There isn't. There is no law passed by Parliament that specifically outlaws murder or describes what murder is. Murder is defined through case law and through the common law, which is quite an interesting piece of information for you there. There are lots of other crimes as well. So there are a number of what we call non-fatal offences, like assault and battery. Those are also common law offences. And the more fundamental example of the common law is and part of the common law that forms the Constitution is that of the Magna Carta of 1215. Now, the Magna Carta establishes a number of principles of constitutional law that are still implemented and still utilised today, and it would be not an act of Parliament, the Magna Carta, but actually a piece of common law. The next of the sources is that of constitutional conventions. Now, constitutional conventions are general rules and principles that are not recognised officially as law, but rather are just general practice that is widely followed and accepted. So they often set out a number of rules that deal with the runnings and internal operations of different political aspects of the state. So A great example of a constitutional convention is what is known as the Salisbury-Addison Convention. And the Salisbury Convention, or the Salisbury-Addison Convention, states that the House of Lords ought not block or delay laws that are passed or bills that are passed by the House of Commons that form part of the manifesto of the winning party. So what I mean by this is, if a political party, let's say the Conservative Party, wins an election, and in the manifesto they say they want to do a particular thing. Let's say they want to pass Brexit and leave the European Union. Imagine if that was something that would happen. If we have this, and they pass this bill in the House of Commons, and this is a bill that was passed as a result of it forming part of their manifesto, the Salisbury-Addison Convention states that the House of Lords should not block or delay that piece of legislation because it forms part of the manifesto of the winning party. The general justification for the Salisbury Convention is that the House of Lords is an unelected body, and if the House of Commons, which is an elected body, is passing a law based on a manifesto pledge, so a pledge that people have actually directly voted for, then the House of Lords shouldn't be, or should have no right to block that piece of legislation. And this is only a convention, though, okay? So, for the most part, these are followed without issue, but where they're not followed, where there is a breaking or a breaching of a constitutional convention, there's no mechanism for enforcement. There's no law or court that will tell them that they're breaking a constitutional convention. The only thing that keeps constitutional conventions together are the fact that they are created by tradition, and we like to follow tradition in the UK, and that's simply the only thing that holds constitutional conventions together. An example of a breach of the Salisbury-Addison Convention was in 1909, when the House of Lords rejected the so-called People's Budget. So you can break the Salisbury-Addison Convention, you can break the Convention of Collective Responsibility, you can break all the kinds of constitutional conventions, but it's just generally poor practice to do so, and generally most people don't. The final source of the UK Constitution refers to works of authority. Now, works of authority are general writings and books that explain and clarify the inner workings of certain aspects of the UK Constitution. There can be old works, like for example A.V. Dicey's The Law of the Constitution, which was published in the 1800s, or there could be newer works, such as the 2010 Cabinet Manual. And just like constitutional conventions, there's no legal enforcement or policy that legally binds these works of authorities and give them legal enforcement. They're just generally followed as a result of tradition. So they're almost a bit like constitutional conventions in this case. And they're only followed because they are works that explain and seek to provide justification and rules and clarification for different aspects of the inner workings of politics and the Constitution. An example that is often referred to is that of Erskine May, which is the work of authority that defines a number of different rules of parliamentary procedure, and Erskine May is followed all the time in the House of Commons and is widely accepted and followed by the Speaker of the House of Commons and is enforced by the Speaker of the House of Commons. Not because there is any legal obligation to do so, but because, again, it's convention that we follow these works of authorities. Now, new works can be adopted all the time. Just for example, the Cabinet Manual was only 12 years ago, and this shows the flexibility of the UK Constitution, because if there is a new work of authority that provides a particularly unique insight into the UK Constitution, it can be adopted and it can form part of the UK Constitution. So these are the principles of the UK Constitution. We've discussed the nature of the UK Constitution, and we've also discussed the sources of the UK Constitution. In the next lesson, we're going to move on to the next of the topics that will be covered in the exam, which is the parliamentary scrutiny of the executive.